Josephine Cafagna reporting there. As candidates line up for next month's council elections around Victoria, many are worried if they're elected, they won't be able to make decisions on issues they're most passionate about. New laws before Parliament will stop a councillor voting on an issue they've previously made a submission on. Some say it's undemocratic and will stop councillors expressing views they were elected for. But the Municipal Association says the law is necessary because many Victorian councils have made biased decisions in the past which are unlawful. The state government says it's still consulting with those affected by the new law. Cheryl Hall reports.
6,000 people saying no! Where's your guts? Reject or resign! Reject or resign!
Local issues often spawn local politicians. In the case of the St Kilda Triangle development, some of these protesters are hoping to replace some of the councillors who approved the plan. But now they fear new laws currently before Parliament will stop them from voting on issues they're most passionate about.
If we take all positions in council, which is a possibility, what happens? The current development, for example, might fall over. We can't even vote about a new development that's more aligned to what the people want, because the people's voice is not going to be heard.
Just down this way. Thank you.
Nominations open this week for election to Victoria's 79 councils. Among the contenders in Port Phillip are 5 candidates from Unchained St Kilda, as well as 6 Greens candidates. All are worried about the effect of the new law on their powers if they're elected to council.
What issues have you made submissions about, do you think you could be stopped from voting on?
Or almost any contentious issue in Port Phillip. The Grand Prix in Albert Park, the St Kilda Triangle, the skate park in Albert Park, the St Kilda Boat Harbour development, and probably several others. I can see issues coming before councils where every councillor has been involved in the past and no councillor would be able to vote on the issue, or less than a quorum would be able to vote on an issue. How would council function in that situation? I don't know.
Under the new laws, any person who's made a submission on an issue such as a planning scheme will be banned from voting on it if they're elected to a council.
We're going to have these bizarre council meetings where we have huge debates as to what can happen, a lot of legal advice and costly legal advice for the electors to have to pay for to try and work out this scenario. And again, the fundamental problem is it really just could allow for a total vacuum, power vacuum at the local government level, right across Victoria.
The legislation is designed to reduce conflicts of interest that have plagued some local governments and resulted in state government intervention. It's been instigated by long-time Port Phillip councillor and head of the Municipal Association, Dick Gross. He says councillors have always been obliged to leave behind their own personal convictions when making council decisions.
The honest truth about myself is that it took me years to get this distinction, and that I, in the early part of my service, made decisions that I now regret, because I went into that decision-making process with a completely, irrevocably closed mind. And I've seen my peers do it, and it made me wince. You know, I would see local ward councillors saying to applicants, you know, I'm going to vote against this and this is going to go down. And in the past, I suspect, we made unlawful decisions.
The common law principle is known as Winky Pop. Last year, a company named Winky Pop successfully challenged a planning decision by the Hobsons Bay Council after one councillor made a submission against its proposed development. The Supreme Court ruled the council had an apparent bias and quashed its decision.
Winky Pop changes nothing but what goes on in our own minds about our own onerous obligations and responsibilities. It was settled law for hundreds of years that you can't bring bias and prejudice. I would love to be able to pontificate and say, I'm a high and mighty councillor, you're right, you're wrong, you're right, you're wrong. It's not the way it is. We live in a judicial world where fairness is not only required but desirable.
The two big administrative law principles, you shouldn't be the judge in your own cause and you should give a fair hearing, have been merged together in that paragraph as if they're the same thing, and they're not. And I think that paragraph would cause real confusion, not only in council but also in any court cases arising from it.
Prominent QC Julian Burnside has advised the local government minister, Richard Wynne, the legislation goes too far.
It would potentially disqualify people simply because they had made a submission on a matter about which they have a firm view. And of course, given the democratic nature of councils, it's likely that councils will include people who have been active in relation to particular issues and have expressed those views by making submissions, for example.
The bill has passed the lower house, but the Greens have announced their intention to amend the legislation when it goes to the upper house next week. Local Government Minister Richard Wynne was not available for comment.
Cheryl Hall with that report.